Good afternoon, everyone, and welcome to today's webinar, Unlocking the Renters' Rights Bill. We're thrilled to have you here with us as we explore one of the most significant legislative developments impacting the rental sector in recent years. Whether you're a broker specialising in let property insurance, a landlord or letting agent yourself, or simply keen to stay informed, this session is designed to provide you with practical insight into what the Renters' Rights Bill really means in practice and how to prepare for the changes ahead. We're especially pleased to be joined by our expert guest, Simon Foster, a highly respected solicitor and partner from Shoosmith, along with his colleague, Becca Hobden, an associate from Shoosmith Solicitors, who bring a wealth of experience in housing law and litigation. Simon will help us break down the legal framework of the bill, highlight implications, and any questions you would like to ask Simon and Becca, please pop in the chat message facility and we will try to get through as many as possible at the end of the presentation. I'm going to hand you over now to Simon and Becca for their experts analysis.
Thank you very much for that introduction, Michelle, and it's lovely to see so many of you attending this seminar. Hope you find it useful. As Michelle said, we are more than happy to answer any questions. If you put them in the chat room, we'll pick them up at the end. I am sure, having spoken to so many people affected by the bill, that you will have questions, so we'll be happy to answer them. As Michelle said, this is the biggest change in housing law in England, and I stress in England, since the 1980s. It's going to have a very significant effect on anybody involved in the housing sector. And what we're going to do in this talk is go through the main headline changes and then pick up any questions at the end. Do you want to go to the next slide? Yeah. So just in terms of the team, as Michelle said, I'm a partner. I head up our residential litigation practice at Shoosmiths. There are some 16 of us. There's some mugshots for a few members of the team. We do everything on the tenancy side. We do north of 1,200 possession claims a year. We advise those in the student sector, those in build to rent, as well as private landlords on anything to do with housing law. And we're also heavily involved in long leaseholder and enfranchisement work. So any residential issues, the team can pick it up. So turning to the bill, I like to start with this first slide because this was the opening to the bill when it was introduced by the government in September. And I think it neatly summarises the aims of the bill. Whether or not you think the bill actually meets them is a different question, but this is the direction of travel. This is what the government want to achieve. So the Renters' Rights Bill delivers our manifesto commitment to transform the experience of private renting, including by ending Section 21 no-fault evictions. The bill will improve the current system for both the 11 million private renters and 2.3 million landlords in England. It will give renters much greater security and stability so they can stay in their homes for longer, build lives in their communities and avoid the risk of homelessness. So as we go through all of the changes by the bill, it's helpful if you can try and keep that in the back of your mind because that will explain some of the why for these changes. So Becca's going to pick up this first slide, setting out that all-important question of when this is going to become law.
Yeah, absolutely. So in terms of implementation, this is still very much to be confirmed. The government have done lots of jumping around in terms of when we expected the bill to come in, and ultimately it's been pushed back to date. So the House of Lords announced that it was at committee stage on the 22nd and 24th of April. That's now completed, so it will go back to the House of Commons. Commentary is still telling us that it's likely to be by the summer recess, so July, August time, but we are still very much unsure as to when the bill will come in, essentially. There is going to be no transition period. So once the bill is passed, it becomes law, it will take effect immediately. There's not going to be a transition period similar to what we saw in Wales when the Renting Homes Wales Act came in. They had a 6-month transition period. At the moment, the proposal that there will be no transition for this bill. And of course, as Simon touched on, this only in England, Wales is excluded. And yeah, like I said, they have the Renting Homes Wales Act, which governs all of their residential tenancies.
So just on this, in terms of timings, the government committed themselves when they introduced the bill to getting this passed before Easter. It was only, as Becca said, it was only halfway through the Lords by Easter. So that deadline has well and truly been missed. The government's next deadline, which we're told is a hard deadline, is before the summer recess. So that's probably going to be July. There's no way they're going to get it through in June. It would be July. But as Becca said, that's looking increasingly unlikely. You know, the official position is it would be before the summer recess. Practical reality is there's a fair chance that this is actually going to be pushed back until after the recess, so into the autumn. As I understand it, they haven't even got a date listed for when the Commons is going to start debating this yet. Big caveat with that is, and we've said all the way through in terms of all of the changes and possible amendments we're going to talk about, is the government have got an enormous majority in Parliament. So if they want to railroad anything through, they can do so. And certainly in terms of the House of Lords, where there are a lot of amendments that have been proposed, it is only the government's own amendments that have been green lighted to go into the bill and to change the bill. Everything else has been pushed back on so far.
Yeah, absolutely.
Okay.
Perfect. I'll touch on
Yeah.
this. So no more ASTs is the headline here. That is essentially what the bill is proposing. So there will be no more fixed term tenancies. All tenancies will move to being periodic or shorter. That comes with the abolition of Section 21 evictions. So there's going to be new extended grounds under Section 8 of the Housing Act, but no fault evictions as soon as the Act comes into force will be no longer. All tenancies will be assured tenancies. The same exclusions apply, so it's best to sort of check that as well. Landlords, in terms of notice period, so 2 months notice period for tenants will come into effect. So tenants at any time during their tenancy can give 2 months notice to leave. Landlords will be required to give longer notice than that currently.
So going back to that opening slide, where you remember the final sentence was to do with security. In housing law in England, the history has always been trying to address the balance between landlord and tenants in terms of flexibility. So in the 1970s, before the Housing Act 88 came in, the balance was very much skewed in favour of tenants. If any of you have dealt with Rent Act tenancies, trying to evict a Rent Act tenant is extremely difficult. Real security of tenure there. We had the Housing Act 1988 tried to address that balance and was perhaps a bit more equal. We then had, from 97 onwards, we had assured short-hold tenancies as the default form of tenancy, which a lot of tenants felt was too landlord-friendly. Section 21 notice, no fault eviction process. So this is an attempt to redress the balance, and what it essentially does is it takes us back to the 80s. By getting rid of ASTs, everything is going to be an assured tenancy. So Section 21 is gone. As a landlord, if I want possession, I have to meet a statutory ground under Section 8, which we'll talk about in a little bit. Now, I've mentioned the exclusions. So under the Housing Act 88, you may well be aware there are some forms of tenancies that do not fall within the Housing Act. So if your tenant is a company, for example, a company let agreement, that's not caught by this. If the rent is over £100,000 a year, so high value properties or even very, very low value properties, they will be outside of the Act. And then, as I said, this flexibility really does tip the balance in favour of tenants. A tenant can give notice at any point, giving 2 months notice. So on day 2 of their tenancy, if they want to, if they've got buyer's remorse, renter's remorse, they can serve 2 months notice. So you'll appreciate how difficult this is for landlords in terms of trying to estimate what they're likely income is going to be from renting a property, because frankly, they're not going to know how long a tenant is going to be there, and they can't rely on a fixed term, at least have a minimum period of time in which they can obtain the rent. So I think this is one of, there are probably two major changes that we're going to talk about: rent control and possession. There are other stuff as well, but rent control is a massive one. And for most of the clients that we've spoken to, this is the biggest concern with the bill for them. So you're renting a property, you've got a prospective tenant before you. You want to evaluate whether or not you want to enter into that tenancy with that particular tenant. So you'd have your credit reference checks. You work out whether this prospective tenant is going to be able to pay the rent during the course of the tenancy, however long that's going to be. Where there is doubt, maybe because you've got a tenant, maybe they're based overseas, maybe they are somebody without much credit history behind them. So student market is very heavily affected by this. The default position at the moment is to ask for rent in advance of greater than 1 month. So that gives you a degree of security. Well, that's going to be abolished under the bill. You will not be able to ask for rent for greater than a month, and indeed it will be an offence for you to do so. So that's one change. Second change in terms of the security point, you remember you're also caught by the deposit legislation. And the Tenant Fees Act limit to you to 5, or if the rent's over 50 grand a year, 6 weeks worth of rent. That's the maximum you can take as a deposit. The other option is you could go down the guarantor route, but that's only as good as the guarantors, if the guarantor's got the money to cover, and if you can enforce against them. So that abolition of the advanced rent is causing a lot of concern, and frankly, in my view, is going to actually prohibit categories of people joining the rental market rather than making it easier for them, as the bill was intending to do. The next issue on rent control is rent review. So a lot of tenancy agreements will have a contractual rent review provision. So every year I'm entitled to increase the rent in line with RPI, for example. Well, those contractual rent review clauses are abolished. They are of no effect. This will be retrospective. So when this becomes law, any such rent review clauses will be of no effect. Instead, all rent will have to be reviewed following the procedure set out in Section 13 of the 1988 Act. Now, that procedure works pretty well. At the moment, a landlord writes a notice, a Section 13 notice, which is dead easy to fill out, sends it to the tenant and says, in 1 month's time, I'm going to increase the rent to X. And I think X represents the market value, market rent for this property. During that month, the tenant can either do nothing, in which case the rent increase just applies, or it can say, no, I think that rent's too high and I'm going to challenge it to the first tier tribunal. And it issues an application to challenge that rent. It goes to the tribunal, which has a specialist bench that deal with rental issues, and they will determine what the market rent is for the property, and they will then set that for the parties. If it is greater than the rent which the tenant is currently paying, the tenant will have to pay the increased rent from the period of time in which the Section 13 notice would have expired, and make up any shortfall in rent that they've been paying. Now, the bill changes those steps that I've outlined quite markedly. First thing, the Section 13 procedures, the period of challenge for the tenant is increased from 1 month to 2 months. Secondly, the tribunal, if it receives a challenge, cannot impose a market rate on the tenancy of greater than the sum that the landlord has asked for. So in a fluctuating market, a landlord might say, well, rent should be X, but by the time it gets to the tribunal is prepared to recognise the rents actually increased during that period of time, and therefore will impose a greater rent. They're not going to be able to do that. The third change, and I think the one that causes most concern, is that there's no backdating. So the new rent the tenant will have to pay will be from whatever date the tribunals determine the rent to be paid, as determine what the rent should be, rather than backdating the rent to when the Section 13 notice expired. So that leads to that final bullet point. There is now no disincentive for a tenant to challenge the rent. If I'm acting for a tenant who receives a Section 13 notice from their landlord, I'm going to say to my client, challenge that rent, go to the tribunal. There's no consequences, downside for you. It doesn't cost you anything because the tribunals are no costs for them. It's only going to take you 5 or 10 minutes to fill out the form that you need to do to challenge it. If at the end of the day the tribunal decides that the landlord was right and you as tenant were wrong and you shouldn't have challenged it, then you're only going to have to pay the increased rent from that date of determination by the tribunal. And if you really don't like the answer, you can give 2 months notice and leave. And obviously you'll be recognising, because that first slide talked about 11 million private rented sector tenants. It is not going to take many tenants to start challenging their rental increases for that system to get heavily clogged up. And as a practitioner, this is something that causes a lot of concern, and is one that, frankly, I don't think the government are taking seriously. And if any of you have read any of the Hansard debates in the House of Lords, there were an awful lot of amendments and comments from Lords on these rent provisions. A lot of them have been the subject of amendments, some really sensible ones, none of which have been accepted to date by the government. I would hope that they will be debated further by the when it goes back to the Commons, but I'm not going to hold my breath. If there aren't any changes, I think we can foresee some serious problems with this, and it wouldn't surprise me if it then gets looked at subsequently. But I don't think that's a good way to legislate. Just going to mention these 2 points, standout points that I think you need to be aware of. The first one is a duty on landlords to give written statements before the tenancy is entered into. So this is aimed at eradicating oral tenancies, which again, as a practitioner, are a nightmare because it can be very expensive to try to undo one. As you'll appreciate, it's all based on witness evidence. In reality, there's no good reason for an oral tenancy. So written statement, we don't know exactly what that's going to look like. That will require secondary legislation, but presumably it's going to be the basics of the let, so the property, the parties' names, the rent, that sort of thing. We have this regime in Wales at the moment where written statements are compulsory, and it works absolutely fine there. The second one is unlawful eviction and harassment. So I would hope everybody on this call is aware of the Protection from Eviction Act and the criminal and civil sanctions of evicting a tenant without following the correct process, including getting a possession order, or of harassing a tenant. The penalties for both of these offences have been significantly beefed up, and all the way through the bill, there is the enforcement powers for local authorities are increasing markedly with very significant fines. And anecdotally, what I'm hearing is a lot of local authorities are beefing up their housing enforcement teams. So this is definitely going to be an increased area of enforcement.
Perfect. So I will just touch on the mandatory grounds for possession. So as we said earlier, no fault evictions will be abolished. So essentially what that means is if you want to regain possession of your property, you will have to rely on one of the Section 8 grounds. So what we've done here is we've not included all of the proposed amendments and grounds. We've kind of just included the ones that sort of will be most applicable to you. So we've got the moving in ground, which is ground 1. This is a ground under the Section 8 of the Housing Act at the moment. The notice period is changing though. So currently the notice period is 2 months and there is no prior occupation requirement. The new notice period is changing to 4 months. It can't be served within the first year of the tenancy, so that notice. And there is also a requirement to show a settled intention to occupy the property. So essentially you will have to rely on, you'll have to provide evidence that you will be occupying that property. We've got the selling ground, which is ground 1A. This is a new ground that's being introduced. So a landlord can rely on this if they want to sell the property. That comes with a notice period of 4 months and again can't be served within the first year of the tenancy. We've got property occupied by students. This isn't a ground at the moment. However, to rely on this ground, you will need to specify in the tenancy agreement that it is a property occupied by students, so it's a student property. It applies if the dwelling is a house of multiple occupation, and essentially if the landlord intends to re-let the property to new students in line with the academic year, they can rely on this ground. That notice period is 4 months.
So I'm right at the end of this talk. I'm going to we won't have a slide on it, but I'm going to specifically talk about the students' situation because of all the sectors, the way the bill's drafted at the moment, they are going to be particularly hit by the changes. So I will talk about that briefly at the end. Becca mentioned the settled intention, which applies to both the moving in and the selling ground. So evidentially, you're going to be able to evidence, as at the date of the hearing, the possession hearing, that there is what legally is called a settled intention to move in or to sell. So in the case of selling, I would expect to see that an agent has been instructed to market the property at the very least. If any discussions progress beyond that, then you'd be evidencing that. Likewise, with moving in, I'd be wanting to put a witness statement in explaining the circumstances in which have caused you to move in, and if that's involved you terminating a tenancy of another property or selling your home, then you'd put that in as evidence that your intention is a settled one.
Okay, so we've got some more mandatory grounds here. These are all grounds which exist already under the Housing Act, but notice periods are changing. So there's a couple of sort of important ones to note. So we've got severe antisocial behaviour. The current notice period is 1 month. That's changing, so landlords can make possession claims immediately. There's the no right to rent ground, that stays the same, so that's a 2-week notice period, and that provides that at least one of the tenants has the right to work in, well, they meet the requirements. The main sort of change, and the one we're sort of seeing a lot of frustration from our clients, is the rent arrears ground. So currently a tenant has to be in at least 2 months of rent arrears at the time a Section 8 notice is served. That's now changing, so that any Section 8 notice cannot be served until the tenant is in at least 3 months of rent arrears. There is the exemption for outstanding benefit payments. But in addition to that, the notice period is changing. So it's going from 2 weeks to 4 weeks. So that's doubling. So essentially what that means is by the time you've served your Section 8 notice, the tenant, and that notice has expired, the tenant will be in essentially 4 months of rent arrears. So that's extremely favourable towards tenants, and especially with the backlog of the court systems that we're seeing at the moment, it's hard to see how they're going to cope with this change in particular.
I think that's a really good point, and it also goes back to the one we were talking about with rent earlier. So if I've got rent arrears, I can't do anything essentially in terms of getting possession until my tenant's at least 4 months in arrears. Well, I've got a deposit which is only going to cover me for 5 weeks worth of rent. I've got a guarantee that may not be worth the paper it's written on, don't know. And I've got, I've not been able to ask for rent in advance for greater than 1 month. So you can, I'm sure you'll be the same as all of our other landlord clients we've spoken to, who can see the sort of manifest unfairness of this, that there doesn't seem to be a way for a landlord to protect themselves against this sort of situation where significant arrears accrue. And as Becca rightly said, we've got a court system that's taking forever to deal with possession claims. I think the National Landlords Association, estimated it's 8 months. It can be as 8 months, I think, is the average to go through now. Our view is, with these changes, the increased amount of court time that's going to be taken up, that's only going to increase. What can you do about it? The options are limited. I think the one that we favour, and that most of our clients favour, is some form of rental guarantee insurance. Seems to be the best way of dealing with this. Obviously, that's an additional cost, and it's not a premium that you can recover from a tenant because of the Tenants Fees Act. But that seems to be the main solution at the moment, and obviously a more rigorous approach to the extent that you can when vetting a tenant at the outset.
So on this slide, we have just covered the sort of common discretionary grounds. Usually when we'll issue possession proceedings, we will rely on a mandatory ground as well as discretionary grounds. So say, for example, we're going for possession under a rent arrears claim. If the tenant pays off the rent arrears just before the hearing, we would go and we'd plead the discretionary grounds that we seek to rely on. So essentially here, we've got various notice periods changing. Some remain the same, but the sort of common ones we've got are breach of tenancy, deterioration of property, deterioration of furniture, false statement. So essentially, with the new legislation coming in, we need to be relying on discretionary grounds a lot more than what we have been previously. So what that means is essentially, if you are trying to evict a tenant and relying on a mandatory ground, we would also try and rely on as many discretionary grounds as possible to really be able to paint a fuller picture for the court as to why you want possession. That's going to be more important now than ever before. So essentially, if you've got a tenant who's not paying rent and they're also breaching the tenancy, you'll want to make sure that you're sort of relying on as many grounds as possible. So
yeah, just on that, I completely agree with that. So just going back to the question of abolition of Section 21 again. So if anybody has served a Section 21 notice before the bill becomes law, that Section 21 notice will remain valid for a period of 6 months from the date of the notice or 3 months from the bill coming into force. That's what the bill says at the moment. So there will still be a window to rely upon Section 21, but it is a narrow one. So putting that to one side, what is the practical effect of the abolition of Section 21? Well, if I am just seeking possession on Section 21, I'm not going after rent arrears, I can go down what's called the accelerated route. Those will be determined by court staff and will only go before a judge if they're defended, and in most cases they're not. Now, because Section 21 is going and everything's going under Section 8, everything is capable of argument, everything is defendable, everything is going to need judicial time to deal with. And as Becca's said, and I would reiterate, with a heavily congested court system, if what we're saying is, even if the government are right and the number of claims before the courts reduce, we'll be going from a huge majority of those cases being ones that didn't require judicial time to every case potentially requiring judicial time. So that is going to take up a lot more time, and therefore lead to further delays. And then finally, on that subject, on Becca's point about the discretionary grounds, is because some of these grounds are going to be easier to defend. So take the rent arrears one. So the mandatory ground is, as at the date of the hearing, I have to show that my tenant owes at least 3 months rent. If at the hearing my tenant turns up and says, well, I've paid 1 month, so actually it's only 2 months I owe you, well, the court can't automatically grant you possession because it doesn't meet the mandatory threshold. You'd be reliant on these discretionary grounds. So you can see there from the chart from grounds 10 and 11. In that situation, the usual court order would be for a suspended possession order, which basically says to the tenant, you're in breach, don't do it again, we're giving you another chance. Now, if you want to be able to argue the task that actually it shouldn't be a suspended order, and instead the court should exercise its discretionary power to grant possession, you're going to need to paint that broader picture. So, for example, in the case of a rent arrears, if you've got a tenant that is persistently late, they're always doing this, they're never paying you the full amount of rent, they're just below each time, I want to present that picture to the court. Similarly, if the rent, maybe they're slightly late, but it's not so bad, but they're an absolute nuisance to all their neighbours. In the past, you might not have worried about that because you just think, I've got my section 21, I don't need to worry about it. I don't need to go there. Here, I'd want to address both issues so that the court can properly exercise its discretion. So we're in the final couple of slides, and these are, this slide is going to, the next two slides are going to deal with some changes that heavily rely on secondary legislation. So there's not too much we can say. The first one is there's going to be a private renter sector database, which all landlords are going to have to belong to. It is an offence, like with everything with the bill, subject to a very heavy fine if you don't comply with it. And also you'll be prevented from being able to market a property or regain possession if you're not a member of the database. What that database is going to look like, we don't know, we haven't been told, but there is a scheme called the Rent Smart Wales scheme, which operates in Wales. It's very good. A click of a button, you can see that the property you're thinking about renting is registered, that your landlord and their agent are both licensed. So I would imagine something in England would be similar. Like a lot of these changes, it's aimed at getting rogue landlords out of the market. Similarly, and the government can consult on this in the second half of the year, apparently. This is the private renter sector ombudsman. Now, quite what the remit's going to be, we don't know. In the world of property litigation, we're quite used to dealing with ombudsmen in different guises. So I do quite a lot in new homes where we've had a ombudsman operating for a very long time, and they can help triage quite a few cases. So your typical disputes as to snagging issues with build without it being serious or high value enough to go to court. I could see the ombudsman operating similarly here, dealing with disrepair, for example, which takes up an awful lot of court time at the moment. But the truth of the matter is we don't know. All we know from the bill is that all landlords will have to sign up to the ombudsman redress scheme. And before Becca finalises, I want to talk about rent repayment orders. Now, I think this is one of the big elephant traps in the bill, which if you read about online, there's not that much coverage of. So rent repayment orders were introduced by the Housing Act 2004, and they allow a tenant to make an application to the first tier tribunal to have their rent repaid for a period of time of up to 12 months for the period in which their landlord was in breach of the relevant sections of the legislation. Now, most of those existing grounds relate to HMO licensing. So typically the ones that come across our desk are where a landlord has failed to get the appropriate HMO licensing for their property. The tenant has found out, tenant makes an application to the tribunal for an order that the rent that the tenant has paid to the landlord for the period of time in which the property was not licensed to be returned to them. And the landlord can defend it, but usually it's a case of mitigating, what's my excuse for not being licensed? So it could well be, well, I spoke to the local housing officer and they told me I didn't need a license. That happens. There are some major changes though by the bill. First one is there's an increase in the number of grounds that can trigger rent repayment orders. And one that jumps out at me and we've discussed as a team is a new ground of knowingly or recklessly misusing a possession ground. So, for example, if I say and I give evidence to the court that I intend to move into the property, and I then fail to do so, I could see that a former tenant could make an application for a rent repayment order, for example. Secondly is the rent payment period which I can recover is now being doubled up to 24 months. So if a landlord gets it wrong, that could be a very significant amount of money. And in the middle one there is, I think, of particular concern. This is aimed at the rent-to-rent market. So at the moment, the law at the moment, and it went up to the Supreme Court, is that a tenant can only pursue a rent repayment order against their immediate landlord. Under the new legislation, the tenant can seek a rent repayment order from anybody up that chain. So if you own a property, you rent it to a company under a company let, they sublet it, they don't comply with whatever legislation they're supposed to have complied with, the tenant goes after them for a rent repayment order, they've got no assets. It's typically the case. The tenant in that case can go, I'm going to go straight after my the ultimate landlord, because I know they've got an asset, they've got the property for starters, so I'm going to seek a rent repayment order from them, even though that party is not the party that's received the rent. So definitely watch out for rent repayment orders. If you've got any concerns that you could be on the receiving end of a claim, do take advice on it, because the amount of money could be very significant.
So I'm just going to cover some of the other key changes which are going to be coming in with the bill. So the right to keep pets. So at the moment, landlords have the right to refuse for tenants to keep pets at their property. This is changing. So landlords cannot unreasonably withhold consent. So an example of reasonably withholding consent would be, say, you let a flat, for example, pursuant to a lease, and the lease has a strict prohibition on pets at the property. In those circumstances, it would be reasonable for a landlord to refuse a tenant consent for a pet. Landlords will be able to apply conditions. So, for example, you can say they can keep a pet at the property, but they need to take out the relevant insurance policy. That's something they are allowed to do, and the fees for that can be recovered too. We've got the decent home standard.
Just on that point, on the pets, question that we get quite a lot is it a reasonable condition to impose on the nature or the number of the pets that have been proposed? So the answer to that is yes, that would be a reasonable condition. So 1-bed flat, I've got 3 dogs. No, that wouldn't be appropriate. We've got a couple of cases at the moment where we involving XL bully dogs. So could I refuse an application for consent to have a pet where the pet is a dog which may be deemed dangerous? Then yes, that would be a reasonable condition. Sorry, Becca.
No, of course. So we've got the decent home standard. So this is sort of moving us over to sort of the similar standard of what we see in social housing. So what social housing providers have to comply with. We've got our Alps law there as well. So essentially what that sort of seeks to do is, at the moment, if a tenant complains of any disrepair, the landlord has to just remedy the same within a reasonable period. What our Alps law seeks to do is it will impose strict time conditions on landlords. So if there's complaints of damp and mould, it will mean that landlords are given an exact time period by which they have to investigate and remedy any of those complaints. We've also got anti-discrimination provisions. So essentially what that means is landlords cannot discriminate against families, children or benefit recipients when looking at potential tenants for their properties.
So the decent home standard in the Alps law, that's going to be secondary legislation. We really don't know what that's going to look like at the moment. It's definitely watch this space. Because the changes will be significant. I do, though, think that when those changes come in, there will be a decent transition period, because to get the nation's housing stock to meet those standards is going to take some time. So I think that was everything, but I did want to just briefly touch on students in case anybody's got any student lets. I said at the start that I think the bill is going to affect the student sector markedly. A lot of these changes have come through in the House of Lords with government amends that they've put forward, which they've obviously accepted, and they've amended the draft bill. So what the bill essentially does, it seems to me, is divide students into 5 categories, which is mad, but there we go, into 5 categories. The first category is those students who are in university halls of residence. They were always outside of the Housing Act. That remains the case. They won't be caught by the bill. The second sector, of the 5 categories of students, is those in the purpose-built student accommodation sector. Now, going forward, it's a big caveat, they will be outside of the bill. Section 33 of the bill sets out what qualifies as a PBSA. You have to be a member of an approved scheme, and really it's the big operators it applies to. In those situations, they will be outside of the bill, and their tenancies can be common law tenancies that will allow them to have fixed terms and to get rent up front and all the rest of it. The third category are existing PBSA operators. So for their existing tenancies, which will be everybody in the new intake, they will convert to tenancies caught by this bill. So for at least a year, PBSA operators are going to be having to operate student tenancies on the basis of the bill, which is causing them a lot of stress. Fourth category is the one that Becca touched upon, which is HMO lettings. So if you've got students in HMOs, then the key thing is to make sure that you've got your ground 4A in your tenancy agreement brought to the attention of tenants before entering into that tenancy agreement, and then you've got a right to seek possession. So you'll be caught by the bill, but you've got an exit from it potentially. And the fifth category is everybody else. So other students are going to be caught by this, are going to be caught by the bill. I suppose there could be a sixth category for those students who have got a sort of lodger's room in a house they share with their landlord. Well, they're still going to be outside the bill. But 5 categories. If you've got students in your properties, I think look very seriously at the terms of your tenancy agreements, or if you operate them as licenses to occupy, at the wording. I'm speaking to a number of student operators at the moment in the PBSA and the non-PBSA sector, trying to find ways of mitigating the potential risks of the bill to their business. I think that's it, isn't it?
Yes, that is it. So I think
We're open for questions,
to answer any questions that anyone's got.
as long as they're not too difficult.
We do have some questions that have already been put in the chat, but thank you very much, Simon and Becca, for all of that. That was very insightful. So a first one which I think should be a relatively easy one to warm you up, is this legislation likely to be rolled out in Scotland?
No, is the answer to that. Scotland, as devolution, Scotland, Wales, England, very different systems. We do quite, as a team, we don't do anything in Scotland, actually. We do a lot in Wales, very different scheme. Interestingly, and there is a debate in Wales at the moment that we've got a Labour government in Wales, a Labour government in England who've looked at the same problem and come up with different answers. So in Wales, you still have the equivalent of a Section 21. It's called a Section 173 notice. And all that they've done there is increase the notice period to 6 months. But they do operate a no-fault eviction scheme in Wales. So there is a debate going on now. Hang on, are we now going to be in a situation in England where it is more tenant friendly than in Wales? Do we need to look again? To which my answer, well, that's the point of devolution. It was supposed to be different. It's supposed to give you the option of reaching a different answer. And secondly, it took them 6 years to bring that Welsh legislation into law. So I don't think there's going to be much of an appetite to revisit that, because the system seems, in our experience, seems to be working in Wales pretty well at the moment.
Yeah.
Okay. Thank you. We have lots of questions about pets. So if you can imagine, it seems to be the kind of topic of conversation from the Act. So what about a block of flats where the building is subject to an exclusion of pets?
And I'd say I think I'd say that if you get a request for consent for a pet, I'd say you can reasonably withhold that consent.
That's a guide. Should be able to reasonably refuse consent in that situation, because actually you'd be putting yourself in breach of covenant by accepting.
Yeah.
Which would be a landlord for your lease. So yeah, that's fine.
Okay, another one about pets. Does the landlord have the right to not allow pets in the property if their insurance policy excludes any damage or loss caused by the pets?
Yes. Alternative is the landlord can take their own insurance policy out, which is appropriate, and they can charge the premium to the tenant, because the Tenant Fees Act has been amended to allow them to do that.
Thank you. And then the policy wording for rent guarantee. There's a couple of questions about rent guarantee. I mean, you can probably give your take on it, and I can give my take on it. So, the policy wording for rent guarantee insurance is quite prohibitive. Do you see this changing even further in light of the bill?
For my take, we act for several insurers. So have a look at the different policies, find the one that's appropriate for you. Is it likely to change? Yes. I'm certainly in discussions with some of our insurers, looking at their policies and thinking about the appropriate wording. There are going to be additional things that the insurer is going to ask for upfront from the insured or the prospective insured, such as the database and the ombudsman things we've talked about. The standard of the properties can become more of an issue. So yes, the wording is likely to change.
Yeah, okay. And I would just reiterate that as well, and that we're currently working with our underwriter to review the policy wording, and then we'll be issuing guidance to all of our brokers to pass on to the policy holders. Okay, another couple of questions. So it says, with regards to not discriminating against benefits or DSS tenants, some insurers won't cover properties where tenants are DSS. Where does this leave landlords?
Okay, I've not seen any insurance policies that specifically do that, but probably are. They will be changing their wording. They're going to have to discriminatory.
And then just touching on the student market, especially overseas students, where they won't pass standard referencing checks. Often they would offer to pay a year up front, which is no longer allowed. What are landlords expected to do in this situation if they don't want to accept an overseas guarantor?
Great question. And what I was trying to convey, I think what the government have done with these changes and the way it's impacting the student sector has really not been thought through properly. So in the House of Lords, there were two, they ended up having extra sessions there. The two main areas for proposed amendments were to do with the rent review, the Section 13 procedure that I talked about, and students. I think that puts the landlords in a really invidious position, and it's going to make it very difficult for some landlords to be able to let to foreign students. Obviously, if it's PBSA, then they'll deal with it. But in terms of individuals, your guarantee is very rarely an option to you, because you can't enforce China or whatever, certainly not at a sensible expense. So you can't ask for the rent up front, so that's not an option. It is going to be very difficult, I think, and I would hope it would change. The insurance that we've talked about is probably going to be the best option. I don't know, Becca, if you can think of anything else.
No, it's difficult. It's something we're seeing a lot from a lot of the clients we act for.
The other option to mitigate, and the one that I'm working with those in the private rented sector who've got students, is trying to draft the documents to make them to bring them outside of the bill, which is not easy, but is to go from a tenancy to a license to occupy, or a tenancy which is outside of the Housing Act because it doesn't meet Section 1. They're only your principal home. So there are potentially ways and means, and they're not without risk, but that can be looked at. But it's not easy to do. So you'd have to look at the documentation and try and put something in place.
Okay, thank you. Okay, this is another great question, I think. So with existing tenants on initial 6-month ASTs, then periodic rolling thereafter, do these now need to be reissued?
No.
No.
It would just be implied. So where it says 6-month fixed term, that would just be scratched out effectively, and it would just say monthly periodic.
Okay. So landlords don't need to update their tenancy agreements automatically.
Correct. They'll want to do so next time they let to a new tenant, but otherwise, no.
Okay, fantastic. Okay, let me just check for any other questions. Sorry. Okay, would professional guarantors assist with OS students, overseas students?
I was reading something the other day which suggests that's going to be that could be the direction of travel that a lot of people end up in. The market seems to be moving that way. Having said that, I haven't seen any of those products yet. I've had discussions with one client which is toying with the idea of offering them, but I've not actually seen anything. I've just read commentary that there will be people doing that.
Okay, thank you. And then I think the final question, hopefully I've not missed any here, but the final question is about rent guarantee insurance premiums, and do we expect premiums to increase in light of the changes?
Michelle, you're probably better placed to answer that than me, but I have to say I think a lot of these changes are going to increase rents.
Yeah.
Counterproductive to that first slide that we talked about.
And our underwriter is on the call and has just typed in the chat yes. So yeah, we are expecting that that premiums will increase as a result of the increased exposure that has kindly just been explained to us. Okay. I think there might be some outstanding questions, but we will have a look through them, and if there are any other questions, we can get back to you separately. So I just wanted to start to wrap up and thank very much Simon and Becca for joining us today. We do have another webinar coming up, so this will be something that Alps host monthly. The next webinar is on the 1st of July at 10 till 10:45. It's a consumer duty training session, which is being hosted by compliance consultants Create. And that's about having your ducks in a row and the board report for consumer duty. So we'll share those details, and we will follow up following this webinar with a copy of the recording and the slides from Simon and Becca from Shoosmith. But thank you very much all for joining us.
Thank you.
Thank you.
Thank you. Thank you.